Section 3 of Beacon Lights of History, Volume 3, Ancient Achievements, by John Lord. This recording is in the public domain. Recording by K. Hand. Governments and Laws, Part 3. With the rise of the Italian cities, the study of Roman law revived, and Bologna became the seat from which it spread over Europe. In the 16th century the science of theoretical law passed from Italy to France under the auspices of Francis I, when Cujas or Cujacius became the great ornament of the school of Bourges and the greatest commentator on Roman law until Dumoulin appeared. Grotius in Holland excited the same interest in civil law that Dumoulin did in France, followed by eminent professors in Leyden and the German universities. It was reserved for Pothier in the middle of the 18th century to reduce the Roman law to systematic order, one of the most gigantic tasks that ever taxed the industry of man. The recent discoveries, especially that made by Niebuhr of the long lost work of Gaius, have given a great impulse to the study of Roman law in Germany, and to this impulse no one has contributed so greatly as Savigny of Berlin. The great importance of the subject demands a more minute notice of the principles of the Roman law than the limits of this work properly allow. I shall therefore endeavor to abridge what has been written by eminent authorities, taking as a basis the late work of Lord Mackenzie and the learned and interesting essay of Professor Mayne. The Institutes of Justinian began with the law of persons, recognizing the distinction of ranks. All persons are capable of enjoying civil rights, but not all in the same degree. Greater privileges are allowed to men than to women, to freemen than to slaves, to fathers than to children. In the eye of the law all Roman citizens were equal wherever they lived, whether in the capital or the provinces. Citizenship embraced both political and civil rights. Political rights had reference to the right of voting in the comitia, but this was not considered the essence of citizenship, which was the enjoyment of the connubium and commercium. By the former the citizen could contract a valid marriage and acquire the rights resulting from it, particularly the paternal power. By the latter he could acquire and dispose of property. Citizenship was acquired by birth and by manumission. It was lost when a Roman became a prisoner of war, or had been exiled for crime, or became a citizen of another state. An unsullied reputation was required by law for a citizen to exercise his rights to their full extent. The Roman jurists acknowledged all persons originally free by natural law, and while they recognized slavery, they ascribed the power of masters entirely to the law and custom of the nations. Persons taken in war were considered at the absolute control of their captors, and were therefore de facto slaves. The children of a female slave followed the condition of their mother, and belonged to her master. But masters could manumit their slaves, who thus became Roman citizens with some restrictions. After the emancipation of a slave, he was bound to render certain services to his former master as patron, and if the freedman died intestate, his property reverted to his patron. Marriage was contracted by the simple consent of the parties, though in early times equality of condition was required. The Lex Canulia, A.U.C. 309, authorized connubium between patricians and plebeians, and the Lex Julia, A.U.C. 757, allowed it between freedmen and freeborn. By the Conventio in Manum, a wife passed out of her family into that of her husband, who acquired all her property. Without it, the woman remained in the power of her father, and retained the free disposition of her property. Polygamy was not permitted, and relationship within certain degrees rendered the parties incapable of contracting marriage. These rules as to forbidden degrees have been substantially adopted in England. Celibacy was discouraged. Concubinage was allowed if a man had not a wife, and provided the concubine was not the wife of another man. This heathenish custom was abrogated by Justinian. The wife was entitled to protection and support from her husband, and she retained her property independent of him. On her marriage, the father gave his daughter a dowry in proportion to his means, the management of which, with its usufruct during marriage, belonged to the husband, but he could not alienate real estate without the wife's consent, and on the dissolution of marriage the dose reverted to the wife. Divorce existed in all ages at Rome, and was very common at the beginning of the empire. To check its prevalence, laws were passed inflicting severe penalties on those whose bad conduct led to it. Every man, whether married or not, could adopt children under certain restrictions, and they passed entirely under paternal power. But the marriage relation among the Romans did not accord after all with those principles of justice which we see in other parts of their legislative code. The Roman husband, like the father, was a tyrant. The facility of divorce destroyed mutual confidence, and inflamed every trifling dispute; for a word or message or a letter or the mandate of a freedman was quite sufficient to secure a separation. It was not until Christianity became the religion of the empire that divorce could not be easily effected without a just cause. The facility of divorce was a great stigma on the Roman laws, and the degradation of woman was the principal consequence. But woman was never honored in any pagan land, although her condition at Rome was better than it was at Athens. She was regarded as a possession rather than as a person; her virtue was mistrusted, and her aspirations were scorned. She was hampered and guarded more like a slave than the equal companion of man. But the progress of legislation as a whole was in her favor, and she continued to gain new privileges until the fall of the empire. The Roman Catholic Church regards marriage as one of the sacraments, and through all the Middle Ages and down to our own day the great authority of the Church has been one of the strongest supports of that institution, as necessary to Christianity as to civilization. We Americans have improved on the morality of Jesus, of the early and later Church, and of the great nations of modern Europe; and in many of our States persons are allowed to slip out of the marriage tie about as easily as they get into it. Nothing is more remarkable in the Roman laws than the extent of paternal power. It was unjust, and bears the image of a barbarous age. Moreover, it seems to be coeval with the foundation of the city. A father could chastise his children by stripes, by imprisonment, by exile, by sending them to the country with chains on their feet; he was even armed with the power of life and death. Neither age nor rank, says Gibbon, nor the consular office could exempt the most illustrious citizen from the bonds of filial subjection. Without fear, though not without danger of abuse, the Roman legislators had reposed unbounded confidence in the sentiments of paternal love, and the opposition was tempered by the assurance that each generation must succeed in its turn to the awful dignity of parent and master. By an express law of the 12 Tables a father could sell his children as slaves. But the abuse of paternal power was checked in the Republic by the censors, and afterward by emperors. Alexander Severus limited the right of the father to simple correction, and Constantine declared the father who should kill his son to be guilty of murder. The rigor of parents in reference to the disposition of the property of children was also gradually relaxed. Under Augustus the son could keep absolute possession of what he had acquired in war; under Constantine he could retain any property acquired in the civil service, and all property inherited from the mother could also be retained. In later times a father could not give his son or daughter to another by adoption without their consent. Thus this patria potestas was greatly relaxed as civilization advanced, though it remained a peculiarity of Roman law to the latest times, and was severer than is ever seen in the modern world. Fathers were bound to maintain their children when they had no separate means to supply their wants, and children were also bound to maintain their parents if in want. These reciprocal duties, creditable to the Roman lawgivers, are recognized in the French code, but not in the English, which also recognizes the right of a father to bequeath his whole estate to strangers, a thing which Roman fathers had not power to do. The age when children attained majority among the Romans was 25 years. Women were condemned to the perpetual tutelage of parents, husbands, or guardians, as it was supposed that they never could attain to the age of reason and experience. The relation of guardian and ward was strictly observed by the Romans. They made a distinction between the right to govern a person and the right to manage his estate, although the tutor or guardian could do both. If the pupil was an infant, the tutor could act without the intervention of the pupil; if the pupil was above 7 years of age, he was considered to have an imperfect will. The youth ceased to be a pupil, if a boy, at 14; if a girl, at 12. The tutor managed the estate of the pupil, but was liable for loss occasioned by bad management. He could sell movable property when expedient, but not real estate without judicial authority. The tutor named by the father was preferred to all others. The institutes of Justinian passed from persons to things, or the law relating to real rights, in other words, that which pertains to property. Some things common to all, like air, light, ocean, and things sacred, like temples and churches, are not classed as property. 2 things were required for the transfer of property, for it is the essence of property that the owner of a thing should have a right to transfer it. First, the consent of the owner to transfer the thing upon some just ground, and secondly, the actual delivery of the thing to the person who is to acquire it. Movables were presumed to be the property of the possessors, until positive evidence was produced to the contrary. A prescriptive title to movables was acquired by possession for 1 year, and to immovables by possession for 2 years. Undisturbed possession for 30 years constituted in general a valid title. When a Roman died, his heirs succeeded to all his property by hereditary right. If he left no will, his estate devolved upon his relatives in a certain order prescribed by law. The power of making a testament only belonged to citizens above puberty. Children under the paternal power could not make a will. Males above 14 and females above 12, when not under power, could make wills without the authority of their guardian, but pupils, lunatics, prisoners of war, criminals, and various other persons were incapable of making a testament. The testator could divide his property among his heirs in such proportions as he saw fit, but if there was no distribution, all the heirs participated equally. A man could disinherit either of his children by declaring his intentions in his will, but only for grave reasons, such as grievously injuring his person or character or feelings, or attempting his life. No will was effectual unless one or more persons were appointed heirs to represent the deceased. Wills were required to be signed by the testator, or some person for him, in the presence of 7 witnesses who were Roman citizens. If a will was made by a parent for distributing his property solely among his children, no witnesses were required, and the ordinary formalities were dispensed with among soldiers in actual service, and during the prevalence of pestilence. The testament was opened in the presence of the witnesses, or a majority of them, and after they had acknowledged their seals, a copy was made, and the original was deposited in the public archives. According to the 12 tables, the powers of a testator in disposing of his property were unlimited. But in process of time, laws were enacted to restrain immoderate or unnatural bequests. By the Falcidian law, in the time of Augustus, no one could leave in legacies more than 3/4 of his estate, so that the heirs could inherit at least 1/4. Again, a law was passed by which the descendants were entitled to 1/3 of the succession, and to 1/2 if there were more than 4. In France, if a man die leaving one lawful child, he can dispose of only half his estate by will. If he leaves 2 children, he can dispose only of 1/3. If he leaves 3 or more children, then he can dispose by will of only 1/4 of his estate. In England, a man can disinherit both his wife and children. These and many other matters, bequests in trust, succession of men dying intestate, heirs at law, etc., were regulated by the Romans in ways on which our modern legislators have improved little or none. In the matter of contracts, the Roman law was especially comprehensive, and the laws of France and Scotland are substantially based upon the Roman system. The Institutes of Gaius and Justinian distinguish 4 sorts of obligations: aut re, aut verbis, aut literis, aut consensu. Gibbon, in his learned chapter, prefers to consider the specific obligations of men to each other under promises, benefits, and injuries. Lord Mackenzie treats the subject in the order of the Institutes. Obligations contracted re by the intervention of things are called by the moderns real contracts, because they are not perfected till something has passed from one party to another. Of this description are the contracts of loan, deposit, and pledge, security for indebtedness. Till the subject is actually lent, deposited, or pledged, it does not form the special contract of loan, deposit, or pledge. Next to the perfection of contracts by re, the intervention of things, were obligations contracted by verbis, spoken words, and by literis, or writings. The verborum obligatio was contracted by uttering certain words of formal style, an interrogation being put by one party, and an answer given by the other. These stipulations were binding. In England, all guarantees must be in writing. The obligatio litteris was a written acknowledgment of debt, chiefly employed when money was borrowed; but the creditor could not sue upon a note within 2 years from its date, without being called upon also to prove that the money was in fact paid to the debtor. Contracts perfected by consent, consensu, had reference to sale, hiring, partnership, and mandate, or orders to be carried out by agents. All contracts of sale were good without writing. Acts which caused damage to another opened a new class of cases. The law obliged the wrongdoer to make reparation, and this responsibility extended to damages arising not only from positive acts, but from negligence or imprudence. In cases of libel or slander, the truth of the allegation might be pleaded in justification. In all cases it was necessary to show that an injury had been committed maliciously; but if damage arose in the exercise of a right, as killing a slave in self defense, no claim for reparation could be maintained. If any one exercised a profession or trade for which he was not qualified, he was liable to all the damage his want of skill or knowledge might occasion, a provision that some of our modern laws might advantageously revive. When any damage was done by a slave or an animal, the owner of the same was liable for the loss, though the mischief was done without his knowledge and against his will. If anything was thrown from a window giving on the public thoroughfare so as to injure any one by the fall, the occupier was bound to repair the damage, though done by a stranger. Legal claims might be transferred to a third party by sale, exchange, or donation. But to prevent speculators from purchasing debts at low prices, it was ordered that the assignee should not be entitled to exact from the debtor more than he himself paid to acquire the debt, with interest, a wise and just regulation. By the ancient constitution the king had the prerogative of determining civil causes. The right then devolved on the consuls, afterward on the praetor, and in certain cases on the curule and plebeian aediles, who were charged with the internal police of the city. The praetor, a magistrate next in dignity to the consuls, acted as supreme judge of the civil courts, assisted by a council of jurisconsults to determine questions in law. At first one praetor was sufficient, but as the limits of the city and empire extended, he was joined by a colleague. After the conquest of Sicily, Sardinia, and the two Spains, new praetors were appointed to administer justice in the provinces. The praetor held his court in the comitium, wore a robe bordered with purple, sat in a curule chair, and was attended by lictors. The praetor delegated his power to three classes of judges, called respectively judex, arbiter, and recuperator. When parties were at issues about facts, it was the custom for the praetor to fix the question of law upon which the action turned, and then to remit to a delegate, or judge, to inquire into the facts and pronounce judgment according to them. In the time of Augustus there were 4,000 judices, who were merely private citizens, generally senators or men of consideration. The judex was invested by the magistrate with a judicial commission for a single case only. After being sworn to duty, he received from the praetor a formula containing a summary of all the points under litigation from which he was not allowed to depart. He was required not merely to investigate facts, but to give sentence, and as law questions were more or less mixed up with the case, he was allowed to consult one or more jurisconsults. If the case was beyond his power to decide, he could decline to give judgment. The arbiter, like the judex, received a formula from the praetor, and seemed to have more extensive power. The recuperators heard and determined cases, but the number appointed for each case was usually 3 or 5. Section 4.